Hello, everyone, and welcome to another episode of Off the Record. Today, I'm joined by Michael Maeso. He is a partner and HOD of the Employment Law Department at Shipston and Wiley Attorneys. Mike has been practicing for over 30 years, and he has frequently acted in the labor courts. Mike is also an avid surfer, and in between drafting court-winning pleadings, he overlooks the ocean in his office and contemplates whether the day is appropriate for a good surf. Mike, thank you so much for joining us today.
Pleasure.
Today, Mike is going to be taking us through what is too casual at work and also what is appropriate for an employee to do in terms of their conduct. To kick us off, Mike, as you can see, I'm wearing a soccer shirt. I'm also wearing a pair of jeans. Am I too casual as your associate?
Well, the good thing about that soccer shirt is that it's not a particular team that is that is well versed in the soccer trade. It's a Shipston and Wiley football team, so that would still be something I think most employers may be a little bit skeptical of, and say, well, maybe that's appropriate for a dress down day. I think one generally would look at what the firm's policy is or the company's policy, because generally you'll find most established businesses will have a dress code. Some businesses actually go so far as to provide corporate wear as a type of uniform, and they do that specifically to avoid this dilemma. So everyone is uniform. You're a bunch of, all the pegs are the same in as they come to work, and therefore there cannot be any doubt as to what you're wearing is it correct or not. Now, if you're in a professional firm such as a law firm, obviously you've got to have your wits about you as to whether you're going to court or CCMA or interacting with the client, because your dress needs to be appropriate. I have noticed, though, as I have reached these advanced years in practice, as you very kindly reminded me, and I like the word practicing because that means I haven't quite got it right after 30 years. I'm still trying. But I've noticed, for instance, now when I go to court, how things have changed in the 30 years. When I first started this road, I mean, it was strict. It was suit, possibly even a three-piece suit, tie, or your bib if you were appearing in the labor court with your gown. And it had to be a dark suit, white shirt, and it was strictly applied to the extent that if you weren't properly dressed, the judge would say, "Who are you? I can't see you," or be simply, particularly sarcastic and cutting to make sure that you never did it again. I've now noticed amongst the younger, I must say, but for instance, in Joburg Labour Court just recently, one of the counsel that I was against was in a very trendy suit, which I didn't think was court appropriate. Lucky he had his gown on, otherwise I'm sure the court would have said something. But no socks. Now, I know it's quite trendy amongst the youngsters to wear no socks for shoes, but I would think as an attorney or advocate representing a client in court, the best thing to do would be maybe pull on a pair of socks with your shoes. That's just the decorum of the environment in which you are in, and it's that type of reading the room, I think, that needs to be applied. When you get to the workplace, of course, things can get a little bit more emotional or a little bit more hectic. In the old days, when you had strong union rivalry, for instance, in a business, there was a big thing to wear your union T-shirt. So although it eventually morphed into just wearing a COSATU T-shirt, which is a federation which has a number of union members, which seemed to be a little bit more palatable. But if you were to wear a NUMSA T-shirt, for instance, in a workforce that was split between SACTWA and NUMSA, that was seen to be provocative and not good corporate practice and not good corporate governance, and that was outlawed. So the courts have accepted the fact that what you would have in the workplace, or at least a rule saying that if you have competing unions in the workplace trying to fight for majority, for instance, that it's not a good idea, and it's certainly provocative for a particular union's members to wear their T-shirt and the other union to wear its T-shirt, because you get that natural rivalry that may occur on the shop floor, and the courts have accepted that as being unacceptable. Now, of course, we've got the Constitution that has crept in.
The freedom of expression, freedom of association.
To the extent that you can say, kill the Boer and everything, that seems to be acceptable. Whether that's going to change things, I don't think so, because those rights they're not sacrosanct. They all have a limitation, and that needs to be viewed in respect of the environment in which the shirt is worn. So I think it would be reasonable for any employer to say, We don't mind a federation T-shirt, which is all one size
Almost
fits
an
all.
umbrella term.
Correct. So we're not outlying union expression, but when it comes to specifics, which may just roll over into some form of violence or some kind of aggression or whatever it may whatever may play out in the shop floor, I think the employer has every right to say that's not acceptable. So that will be more at a political level. Also, for instance, you can imagine at this moment in time, if a group of employees rolled up wearing Free Palestine T-shirts, for instance, in an environment that may be across the board, there may be a strong Jewish element in the business, or even people that may not necessarily support the Palestinian movement and find that what happened not so long ago completely unacceptable, and therefore supporting what Israel is doing. So that in itself may play out in a form of aggression or violence on the shop floor, which an employer is perfectly free to manage and say that's unacceptable. So I think it's just really common sense that should apply in these instances. If you don't have a policy, and I would recommend that if you're a corporate, that you put in place a policy just so that the rule is clear to everybody. There
And
can
it's
be no
uniform.
doubt.
No pun intended.
No pun intended. Exactly. And you just make it clear, no political slogans, those type of things. It's just not acceptable. So I think that from a political side is fairly obvious. You then move into possibly the more personal issue as to, is that outfit appropriate for work? There may be a plunging neckline or particularly tight clothing or with slits or whatever it would be, which is highly provocative, which is clearly not appropriate in not all business. I suppose if you're a particular business that may be selling those type of goods, well, then it's different. But obviously in a normal business, I think that's totally inappropriate, which is why, as I said, it's not a bad idea in some environments to impose upon your employees
corporate wear,
some form of corporate wear. That takes this whole equation of are you allowed, are you not allowed, out the park. You're therefore not compelled as an employer to make a hard decision and face the wrath of someone wearing an EFF beret or red T-shirt, which may be manipulated and may cause problems of its own. You deal with all of that out of the equation, and you'd say, well, here we have corporate wear. It's neutral. If you're on the shop floor, you wear an overall, and if you in an office space, well, then you wear a chinos and a shirt with a corporate logo, and maybe the ladies have something else that is designed for the particular company. The cost, of course, is then always a question as to whether the employees need to pay for this. A lot of companies they subsidize it. They don't always give it free because otherwise it can be abused. And then again, you're going to have to have another set of rules in place as to what you do with that corporate wear. Are you allowed 2 or 3 sets of clothing a year? What happens if you lose it? All those type of things would need to come in. So,
would that be provided in the policy?
Yeah, I think it would be. So you as a corporate would make a decision. Okay, we have a potential for drama if we allow employees to make their own choice in respect of what they want to wear, because we either have a highly politicized environment, which is now there's now an encroachment from another political party, and that's playing out in the workplace, and we don't want that to play out in form of strike action or go slows. So you either impose the rule up front by saying no political slogans, and do you stop with political slogans, or do you extend it to sports teams? If you're in the UK, for instance, you may have a Manchester United supporter that takes,
and it can get highly emotive.
Takes significant umbrage at someone wearing a Spurs shirt. Whether we have that here between a Stormers T-shirt and a Sharks T-shirt, I don't think so. But what about Kaizer Chiefs and Amazulu and Orlando Pirates? There may be significant emotion attached to that, particularly at cup final stage and those type of things, where the sports aspect of it is lost and it becomes more emotional. So it's something just to think about. And maybe certainly if you as an employer are having a corporate event or a staff event where there may be a little bit of liquor flowing around and that type of thing, you may want to avoid these little triggers that may in themselves seem insignificant at the start of proceedings, but become the cause of a particular problem down the line. And then what do you do if there is a problem? Because if you go to court or the CCMA, they're going to say, well, where's your rule?
Yeah.
Did you explain to everybody that that's unacceptable? Or are you imposing this rule after the fact? And therefore, then, is it fair to discipline somebody against something that they had no idea what it was or what the standard was that they had to meet? So it's, again, common sense, I think. So one doesn't want to be draconian or totally prescriptive and paternalistic over your employees, but by the same token, you've got to have a fair sense, I think, of what is unraveling on a daily basis in the bigger environment than your workplace, and see if anything that is likely to be worn could spill over in your workplace, which then you are responsible for and you have to manage. Because remember, in terms of your legislation, you as the employer have a statutory duty to ensure that you keep a safe workplace. Yeah, exactly. You've got to be able to show that you've done everything possible, everything practically reasonable to ensure that your employees are safe at work. So if you invite an environment which causes conflict, then you could be in trouble in respect of that. And more importantly, the consequences of that issue may be problematic. If there's an injury on duty because there's a fight or an assault caused by what the person has worn, but you've allowed that to happen, is that something that's going to be taken into account? Maybe, maybe not. It's something that hasn't really been decided by the courts. But you can see that this is an onion that has many rings, and you got to peel it very carefully, I think, to decide what is safe and what is not. But I would think if you just apply a general common sense approach, you have a general policy saying no T-shirts with political slogans or support of political parties, specific trade unions, or religious aspects as well. I mean, that could also blow out. Even gender-based issues possibly may be problematic. So you would have to just say that everything needs to be neutral, and then I think you could get away with it. Particularly when you have like we do at Shepston and Wiley, we have a casual day on Fridays. I notice of late that seems to be morphed into a number of days other than Friday, and I may be guilty of that. But that's when things can go wrong, in my view, because then you may get the inappropriate attire in terms of provocative or not necessarily professional. Although it is a step down day or casual day, there still needs to be an eye on the door as to
some
what it is. Some
form of decorum.
Correct. Yeah. I mean, you can wear the latest jeans than the T-shirts, but obviously it's a good idea to cover most of your body at the same time. I think is a good idea. And this whole thing of dress has been around forever and a day. When I worked in London many years ago, I worked in one of the firms which is described as a magic circle firm, which is normally as a male attorney, you had to wear a starched white shirt with French cuffs. That's the double cuffs, cufflinks, a dark suit, and black brogues. Otherwise, you were not part of the team, and you'd get frowned at. I moved into this firm; it was third largest, and they moved away from that. They suddenly went chinos and whatever, unless it was client interfacing. And then it was amazing how many firms followed that after a while, because they realized you actually didn't drop in terms of standard or behavior, and people were just more comfortable, especially there. Where the majority of, probably like here, although I don't think it's quite understood in the same way, so many people rely on public transport to get to work, and you're jammed in these tubes like sardines in a can. So wearing a suit in summer, which is in a sardine can, which is not air conditioned, is not a very pleasant exercise. So it just made that travel to work a lot easier, and people were very appreciative of the fact that they could dress down. I must say, as a South African, I went and my idea of dress down casual was a lot more sophisticated and a lot more regimented than some of my colleagues who looked like they had just sort of slept under the bus for the night. But that's the way it was. But again, it was a common sense approach to what it was that you would wear.
So, Mike, what I've gotten from today's episode is the importance of having a policy in place.
Yeah.
And to make sure that everyone is on the same page, there's uniformity across the workplace, and we all have an understanding of what we are allowed to do and what we're not allowed to do. And employers need to make sure that they comply with their own policies to avoid a spillover of issues.
100%. You must remember there's fundamental principles with any dispute that goes to Labour Court or CCMA when you're dealing with an act of misconduct. And that is the first thing they look at, well, is there a rule in place? So in this instance, is there policy that dictates what it is that you can wear? Or has there been a rule expressed to everybody, this is what you can wear, this is what you can't wear? That's the first thing. Then the second thing, obviously, you have to show that there's been a breach of that rule. And then the third thing, which is very, very important, we haven't touched on that, and that is the consistent application of that rule. So it's no good having that rule for a body of the workforce, but not the others. You know, why are they allowed to wear a T-shirt which says XYZ, but I can't just because I'm labeled a blue collar worker? So you have to have that consistent application, and that goes all the way to the top. You can't have an MD that rolls in baggies and slops in a T-shirt, yet he imposes a rule on the workforce. I mean, you got to expect that rule then not to be seriously applied. But those are the things that you need to show. So as you correctly pointed out, policy or strict rule that can be established and a consistent application of that rule. And then you should be clear to go. And obviously if you don't, well then
that's where you come in.
Phone us.
Thank you, everyone, for joining us for today's episode of Off the Record with Michael Maeso, a partner and HOD of the Employment Law Department. Please join us for the next episode where we will be discussing another cutting-edge topic in the space of employment law.